right? We have class on Monday. We're going to do the makeup class on the Tuesday, and we have the review session. And after that, we're through. And it's strange that, we get to the most, I think, salient, the most significant issues of the semester all the way at the end. Most things we've done so far, frankly, have not been that important, right? They're significant issues, but from a contemporary perspective, they just don't really have much resonance, right? They're just not that salient. But today's class, the class on Monday and the class on Tuesday are quite salient. What we're doing issues that, frankly, continue to divide the country. And they're not simple issues to discuss. And these are issues in which people have very strong opinions, irrespective of constitutional law. That is, people have been thinking about these issues for a very long time. The specifics of the American Constitution don't always make a big impact on how these issues are viewed. So my hope is when we handle these classes, we can do so as much as possible. It's not always possible, but as much as possible, thinking about the legal questions. But of course, I'm always happy to talk about whatever you all want to talk about. All right. All right. So let's get started, and let's just maybe review a little bit our discussion of the Due Process Clause. We spent a couple classes talking about the Due Process Clause in the early 20th century. And what we learned is that the court had taken different approaches to the Due Process Clause. There was not a single approach. And in different years, the court viewed due process in a different fashion. And there are different sort of phases the court went through. And I can just review these for you briefly. In the early 1900s, 19-teens, 1920s, the court followed the model from Lochner. This period is even called the Lochner era, right? And during this Lochner era, the courts reviewed legislation with what was known as presumption of liberty. The idea that it's the government's burden to intrude upon people's freedom, and they had to provide evidence to justify that burden, right? These laws were not presumed valid. And we saw in cases like Lochner, in Meyer, in Pierce, in Atkins, and others, how the court was very skeptical of legislation that intruded upon rights of contract, for example. And then we saw, during the 1930s, a shift from a presumption of liberty to what you might call a presumption of constitutionality. And this presumption, in cases like Nebbia and West Coast Hotel, granted deference to the state. And it presumed that the state was acting lawfully. But still, with this presumption of constitutionality, the challenger, the person who was being regulated, could introduce evidence to dispute the validity of the law. And then we come to Caroline Products in footnote 4. And Caroline Products in footnote 4 sort of modified or qualified this presumption of constitutionality. And footnote 4 laid out these, these 3 paragraphs. And these 3 paragraphs were illustrations of when this presumption of constitutionality would not apply. For example, if a law violated a specific provision of the Bill of Rights, you would not review this law with presumption of constitutionality. Or if a law affected the so-called discrete insular minorities who couldn't protect themselves in the process, you would not use a presumption of constitutionality. The footnote 4 was largely theoretical. It wasn't relevant to the case before involving filled milk. It was sort of just this theory they put out there. And it's not clear how often or even if it was ever even followed. We studied Brown v. Board of Education. You'd think they'd cite footnote 4. My goodness, it's school segregation. But there was no discussion of footnote 4 anywhere. All right, so what you've seen now, a couple classes removed from the 1930s, is that footnote 4 really didn't apply in any sort of consistent fashion. It was sort of just this principle looming in the background. But then we get to the 1950s, and we get to the Warren Court. And by the time we get to the Warren Court, it seems that the justices just don't want to be in the business of reviewing the validity of legislation, right? Unless there's a specific, textual command in the Bill of Rights that says you cannot violate speech. The court says we should let the democratic process work its way through, right? The due process clause should not be used to second guess the legislative process. Okay. All right. So that's 1955. And the case was Williamson v. Lee Optical. This is with the eyeglasses case. Okay. Lee Optical. All right. So those are those 4 phases. You had Lochner and the presumption of liberty. You had West Coast Hotel with the presumption of constitutionality. You have Caroline Products with this sort of qualified presumption. And you have Lee Optical, which is this sort of this irrebuttable presumption of constitutionality. Can't be rebutted, or almost certainly cannot be rebutted. Right? No evidence can rebut it. So these 4 sorts of phases, and the court's never said there are 4 phases. This is just how Randy and I review it, but I think it's a helpful way of looking at this 50 years of history. Actually, that's 50 years from Lochner to Lee Optical. We have just about 5 decades, about 50 years. But then we get to the 1950s, and we start seeing cracks in this sort of New Deal and post-New Deal settlement, right? They have this sort of Lee Optical, we're settled, we're done, we're not going to be in this business, and it's sort of cracking open. And the first cracks came in cases involving criminal procedure, right? I don't know if you've taken Crim Pro yet. I think you will at some point soon, hopefully. It's a good class. But in the 50s and 60s, the court began to look very carefully at law enforcement and suggest that the law enforcement agencies were not behaving properly, and they had to give certain rights to defendants. Now, some of the cases, were based on the text of the Fourth Amendment, which says you have the right to be free from unreasonable searches. But other cases from this era started using a word, and that word was privacy. Privacy. Now, you can read the Constitution. I've read it many times, and the word privacy appears nowhere. It's not in there, right? It's not in the Constitution. You can flip through it no matter how many times you want. You will not find that word in the Constitution. But in the 1950s and 60s, it's become a very important concept that we need a right of privacy from the government. We have a right to, your own affairs that are private. And maybe this is good, maybe this is bad from a policy perspective. I don't really care. It's not my interest. But this was a concept that wasn't really in the Constitution. And this focus on privacy created a tension with footnote 4. All right, what was the tension? Footnote 4 says, if there's something listed in the Constitution, that means the courts can be pretty sure it's there, and the courts can give effect to that right. But if it's some sort of unenumerated right, a right that's not written down, then maybe the court should not be getting involved. So what about privacy? Well, the courts seem to suggest that this term of privacy maybe wasn't written down literally, but it was premised on some of the other amendments in the Constitution. The right of be free from searches and seizures. So it's not exactly written down, but it's close enough. And this was a sort of rationalization by the New Deal justices, these are almost all Roosevelt appointees, to stay within the footnote 4 framework, stay within the Lee-Optical framework, but still recognize that society wasn't where they wanted it to be. That is, the justices weren't happy with the way the elected branches were working, so they in fact did want to substitute their own preferences. And they use, fancy words to describe it, but there's not much of a difference between the sort of review in these privacy cases as it was in Lochner. I suppose one difference is there was good evidence that the 14th Amendment did protect right of contract. Think of the butchers and slaughterhouse and the attorney in Bradwell. This right of privacy just sort of came around much later. But the notion that the courts could assess whether a law was arbitrary or whether a law was unfair or improper was a sort of jurisprudence that Justice Holmes hated. He hated it, right? He detested it. And what you see in the 50s and 60s was basically this return to substantive due process, as it became known. But not all kinds of substantive due process. The court would draw a distinction, and you'll see this very clearly in Griswold. The court would draw a distinction between sorts of economic rights, rights of contract, rights of property. Those were still given the Lee-Optical treatment, right? Those were not very important rights. But then you had what were called personal rights, or rights of privacy, or rights of intimacy, or rights of family, right? The court seemed to suggest that these rights were different, that these rights would be given, more protection by the courts, that laws that burden the rights of privacy would be viewed more skeptically. Why? The answer does not come from footnote 4. I think the answer comes from the justices. They just didn't like property rights. They thought they were not very important. But they felt that in the 50s and 60s, you have the sexual revolution, people swinging and doing all these crazy things. We need to have a more, we need to have a more permissive society. And our conservative, I don't mean Republican, but just the conservative society that was very opposed to these sorts of social issues was just not with it, was not with the times. And the court had to get ahead of that and to ensure that people had this sort of social rights. That's history, right? We all know that's true, but why? Right? The court was conflicted. How can they do this change, right, without ignoring the New Deal settlement, without ignoring Caroline Products and Lee-Optical? And the output is not very pretty. And by that I mean Griswold. Now, this is a decision which, most people today would not file a court challenge to argue that Griswold's unconstitutional. I just don't think that's very likely. Roe, different story. We'll get to Roe later in the class. But for the most part, Griswold doesn't seem to be much in jeopardy. But the basis of Roe is Griswold. And you can't have one without the other. So really, attacks on Roe have to be attacks on Griswold. And Griswold is sort of the root of the entire doctrine. So let's start with Griswold. Try to focus as well as we can on Justice Douglas's reasoning. And we'll try to keep in mind how Griswold did or perhaps did not lay the framework for the big one, Roe, which we'll get to later in the class. All right. Questions in that sort of introduction or monologue, whatever you want to call it? That was a lot. I tried to condense like 50 years to a few sentences. Okay. Yeah, Harrison, go ahead.
You said that in the late 50s there was a return to substantive due process?
Correct.
Could you give a definition of what that is?
Yeah, I've done it before. I'll do it again. The phrase due process, right? Process, suggests that the government can take away your property if they give you certain procedures. For example, a trial, a jury, a hearing, a judge, the right to present evidence, the right to confront your accusers, right? These are all very well established rights of process. They can't just flip a coin or toss a dice and decide if you're guilty or innocent. Think of the lottery I talked about. So there's not much of a dispute about procedural due process. People might argue about what processes actually do, but they argue that there's some basic procedures to have a legal system that you need. Right? We don't roll the dice. We don't flip a coin. But the Lochner style cases and frankly the Griswold style cases were not concerned with whether Joseph Lochner was given a fair trial. Right? They were not concerned with whether Estelle Griswold was given a fair trial. Right? They were not concerned with whether Joseph Lochner had a right to challenge the evidence put in front of him. Right? That wasn't what these cases were about. Instead, they were cases that challenged the lawfulness of the statute itself. And we say, was the law itself valid? Or was the content of the law valid? What's a synonym for content? The substance, right? Was the substance of the law valid? With substantive due process, the courts ask if the substance or the actual meaning of the law is consistent with the due process of law. We're not asking if they're given a fair trial. They were in these cases. That wasn't an issue. The issue is whether the courts can say that the substance of the law itself is consistent with the due process of law. That as a due process of law requires some sort of fairness, right? And some sort of non-arbitrary content. And if a law deprives you of that, if the law has like an arbitrary content to it, it is not consistent with due process of law. It takes away your liberty inconsistently. That's not a very good definition. It's the best I can do now because there's no good definition at all. But the general gist is you have these two branches. You have procedural due process and substantive due process. And they both sort of get at different ways of challenging laws as violations of the 14th Amendment. How was that, Harrison?
Thank you. That's great.
That wasn't great. It was awful. I wish I could do it again. But it's a very hard concept to explain. And whenever I try, I always hate myself because that's not good, Josh. The reason why is the court doesn't really use the phrase substantive due process. A couple of justices will, but they don't usually say it. And they never define it. Because to define it is embarrassing. It's like, we're doing this thing, we don't know what the hell we're doing, so let's just not say it. Like, let's just pretend we're not doing it. It's one of those things where if you don't talk about it, it's not real. But that's the best I can do right now. Thanks. Other questions? Okay. Who's next?
I believe it's me, Professor.
Okay, Husna, thank you, ma'am. You want to please give me the facts in Griswold?
Yes, okay. So basically we have a Connecticut law that banned the use of contraception and also from people counseling couples to use contraception.
Okay, just a brief note. How do you enforce a law like this?
With policing power of the state.
Okay, yes. But how do you actually enforce a law that bans the use of contraception? Generally, not always. Where is birth control used? I mean... Is it used in public?
No.
Okay, where is it used?
In private.
Okay, in private. So let me ask the question again. How on earth would this sort of statute be enforced?
Oh, like have a fine on getting the product?
No. I'm asking how would you prohibit the actual use of this product? I know this is a stupid question, but I'm trying to get at a point here. How would you ever actually enforce this statute? I mean, what would have to happen for this statute to be enforced to prohibit the use of these products?
They would have to find out that you're using it in the
Yeah, and how would the police actually see evidence of you use? Okay, I'll leave you alone. Right. Okay, good enough. Right. I'm putting her on the spot, but I shouldn't. I apologize. But this is a statute that's virtually impossible to enforce. And according to what I've read, Connecticut didn't really enforce the statute. Right? This was an old law that existed from many, many years ago. And it simply wasn't enforced. It was one of these laws where you sort of looked the other way, right? It was on the books, but no one followed it. Okay, so now, go on, Husna. If you have a law that's not being enforced, why did this case even exist, right? Why does anyone care to challenge a law that really was not being enforced? That's my question to you.
Well, I know it was a test case.
A test case. What does that mean, a test case?
So basically, it's a case to challenge the validity of a law.
Okay. Okay, thanks, Husna. I appreciate it. Thank you. All right. Oh, God. I wasn't looking at the chat for 30 seconds. What happened? I'm just going to scroll. Never mind. Some of my colleagues have banned chats. I think I know why. I don't care. In Connecticut, in the 60s, they had this law in the books that simply wasn't being enforced. But groups like Planned Parenthood wanted a test case, right? They wanted the Supreme Court to establish this right to contraception. But that presents a challenge, right? If a law is not being enforced, how do you challenge it? Now, you might have seen reference in your case to Poe v. Ullman, P-O-E versus U-L-L-M-A-N. That was a case decided a little bit, maybe a year or two before Griswold. And in Poe, you just had basically a challenge to the Connecticut law. And the court said, wait a minute, no, you can't just challenge a law in the abstract. No one's enforcing it, right? You can't just go to court and say, I want to challenge law. You have to be injured by it. Okay? So, who's next? Benjamin, you here? Benjamin? No Benjamin. Lewis, you here?
Yeah, I'm here.
Thank you, Lewis. So let me ask this question. How did Griswold go about challenging a statute that was not being enforced?
So it was the people who were giving, they just kept offering contraceptives to couples and counseling for these contraceptives so that they could get, I guess, caught to have a case.
Yeah. How do you think they got arrested? How do you think this went down? Just, you can kind of read between the lines here.
I think they were probably making it very obvious that they were giving counseling. They were offering counseling to people to the knowledge of using contraceptives.
Good. Lewis, one more question. Now, in the video, which I don't know if you watched, but you probably should watch it, there's a photograph of them getting arrested. You saw that picture? Do you remember that?
Yes, sir. I believe so.
Generally, when people get arrested, are the newspaper photographers present?
No.
How do you think the newspaper photographers were present when these guys were getting arrested?
Because I think they were trying to get arrested. They were trying to make their test case.
It was a setup. It was a complete setup, right? You know, I mean, you call it civil disobedience, call it whatever you want, right? But they deliberately violated the Connecticut law. They called the newspapers in, said, hey, we're going to get arrested. You want to come by? And it was a complete setup, right? This was all designed to manufacture litigation. This is like, a classic test case, right? A classic test case. All right? Now, so Christopher here? Christopher? No, Christopher. Okay. Dina, you here?
Yes.
Thanks, Dina. Now, Dina, who exactly were the defendants in this case? Who was actually getting arrested?
I believe it was the executive director of the Connecticut Birth Control League. That was Griswold. And Buxton was the chairman of the Yale University Department of Obstetrics and Gynecology.
Okay, very good. Now, were these people actually using the birth control? I mean, I don't know if they were. I don't think they were a couple. But I mean, just at least in their own rights, were they using birth control? Do we know?
Not as far as we know. They were just counseling married couples.
Now, wait a minute. Why? Dina, help me out here. How is it that you have a constitutional right to basically write a prescription? I mean, that's what counseling means, right? Let's just be blunt, right? They were basically giving prescriptions for birth control. They were handing these products out, handing out literature, right, and writing scripts, right? Actually, they probably couldn't write prescriptions because it was illegal, but at least handing out the product, right? How do you have a constitutional right to hand out medical devices? I mean, just we're talking at the bedroom and privacy, but these were basically doctors, and I don't even think Griswold was a doctor. I think she was just a manager, right?
Mm-hmm.
How is there a constitutional right to hand out medical devices?
I'm trying to think of it from the constitutional side.
I mean, what's the,
I guess honestly, I can see it from like an economic liberty.
Oh, so this is like locked. You have the right to make contracts to distribute birth control. Is that the argument?
I mean, as far as handing out, if you're a doctor, like that's your job. So
this is like the bakers working 80 hours a week. It's not a bad argument. But Dina, just one more question. I'll let you off.
Mm-hmm.
Who would be the ideal person to challenge this Connecticut law? Is it the Planned Parenthood doctor? Who would be the right person to challenge it?
I would think someone that would want to be using the contraception.
Who would that be?
The patient.
The married couple, right?
Yeah.
Okay, good. Thank you. Right, so there's a lot of, I always focus on these procedural things because you're going to be lawyers soon, right? You have to think about how to bring a case. This was just such a strange case, right? You had a law that wasn't being enforced, and the people challenging were people who weren't subject to the law. They weren't the ones actually using the birth control, people who were distributing and counseling it, right? Now, the law banned the counseling as well. So let me just give you insight to the argument. In law, it's very often the case that the people challenging the law are not the people who are themselves asserting a right. Rather, it's people who are connected to those asserting the right. And Griswold was one of the first cases that allowed it, but it wasn't the first. You studied one before. Pierce v. Society of Sisters. In that case, the Order of Nuns was able to sue and assert the rights of parents to raise children. So at least you have one case where that model is used. We have one in Griswold. You did one last class in Craig v. Boren, where you had a grocery store, the Honk and Holler, my favorite name ever, the Honk and Holler in Stillwater, Oklahoma, that allowed a grocery store to sue on behalf of men who want to buy beer. Now, Gavin asked, does this not create an issue of standing? Absolutely. And there are some people who think there's no standing here, right? That you can't have a grocery store sue on behalf of a man, right? Or if you have a doctor challenging the contraception statute, he can only assert the right of a doctor. He can't assert the right of a married couple, right? I mean, let's be frank. The way this case could have gone down was you had a married couple who were in the bedroom using contraception. They got arrested, and that was their case. But would that ever happen? Did the police ever break into a private home to watch people having sex? I mean, does that ever happen? Actually, it does, apparently. Lawrence v. Texas, you'll read about next class, which is exactly the case. Sorry, I set you up for that one. Which is exactly the case began, where basically cops went to people's house and they thought they saw two men engaging in sexual relations. But as a general matter, thank you, Cassidy. As a general matter, the police are not in the business of looking at people in the bedroom. I mean, I guess it happens. So you have a lot of these sorts of abortion cases not involving the patients themselves, but involving the doctors. Indeed, one of the reasons why Roe is so unique is you actually had a person. She was not named. They used a fake name, Jane Roe. But you actually had a person who's pregnant. Most other abortion cases involve the clinics themselves. Right? They involve Planned Parenthood or Whole Woman's Health or some other clinic. All right? Come with me. All right, that was Dina Harrison. You're back. You weren't away for long. That's what I did there. That was really bad. I'm sorry. That was terrible. I'm waiting all semester for that one and finally give me a shot. Actually, it just came to me. All right. So now give me the facts of Griswold. What actually happened here? I cut Hosen off after 3 seconds.
So, like what led to their arrest, essentially?
Mm-hmm.
Okay. So Griswold was the executive director of Planned Parenthood League of Connecticut. Buxton is a physician and a professor at Yale Medical School who served as the medical director at the same location. Both were arrested after the clinic had been open about, I think it was 10 months or so. And they were arrested for giving information to married people on how to prevent conception.
Okay, good. Now, Harrison, let me ask you just one more follow-up question. Generally, I'm sure you've been to doctors in your life, right? They're allowed to write prescriptions for certain, medical devices and different medical products. Mm-hmm. Can a doctor just hand you something under the counter that's illegal? Oh, he's like, I got this great hydroxychloroquine, too soon. Can they just hand you a product that's not legal? Is that something doctors can do? Can they write prescriptions for things that aren't authorized by state law?
No, they can't.
So why isn't that the end of this case, right? How come, forget the rights of privacy, forget the rights of sexual autonomy, whatever. How can there be a right to issue a prescription for an illegal product?
Well, they said that it came down to like the state interest that was used to justify this law actually contracted the knowledge that was available. And really it was less of a conveyance of a prescription by a doctor and more of like, here's a general knowledge.
No, there were devices. There were products they were recommending. There were foams and there were condoms. There were things that, might look, ancient by today's standards, but they were devices that were used.
Mm-hmm.
Isn't this just a case where you have doctors prescribing illegal products?
No, I don't know. I guess you could make that argument about it being a prescriptive.
Was anyone stopping these couples from having relations in their bedroom?
No.
So what was their problem?
My understanding was just more of their privacy, not within the professional relationship of the doctor.
Right, but we're talking about the privacy of the bedroom, right? But these are products being distributed in a storefront in Connecticut. It's a public building, right? I'm trying to get a point, Harrison, and I think you're sort of fighting it, but that's okay. No one was regulating private relations. The regulation only concerned an interaction that people have with their doctor, which is something the state always regulates. The state routinely regulates what doctors can tell their patients and what they can prescribe. So what's the connection between counseling people in a medical office and what the couple does in their bedroom? I'm trying to get that one point.
Had to do with I'll make one last stab and you can go to somebody else who wants.
That's fine. I appreciate that. Go on, take your last stab. That's fine.
It would have to do with the health of the individual and your right to seek out information from your doctor that has to do with, I would say that the health of the individual and the couple physically and how to, never.
Oh, okay. Let me. Who's next? Is that Morgan? Morgan, you next?
Yes, I am.
Morgan, let me ask you a question. What if what if the state says that, we don't want people hanging out information on, snake oil. I'll just make a product, right? It's an oil that people say helps cure diseases, but it just actually has no medicinal value, right? Snake oil. And you say, well, I want to have knowledge about snake oil. Can you have a constitutional challenge that you have the right to talk to your doctor about snake oil? Is that
I mean, I think as it's associated with your personal health and like your
snake oil. Yeah, it makes me healthier.
Yeah. So I guess to inquire knowledge from someone who studied it, I think that's the responsible thing to do. I don't know, the snake oil thing is weirding me out.
But why? It's you're seeking knowledge, and the state says we've determined that snake oil is not good for you.
I mean, but the state isn't doctors. The doctors know what's good for you. And if
but doesn't the state have the power to decide what products are available for prescriptions for?
Yeah.
So what's going on here? Why is this any different?
Well, because with the contraception, that's dealing with like marriage, and that's like a private.
But they're allowed to have marital relations. Nothing's stopping them.
But this is like regulating like their family size. Basically, the state would be telling them that like, oh, you can't have children. You can have children.
Oh, people have been regulating family size long before contraception. I'm giving you a hard time deliberately. I'm trying to make a few points. Thanks, Morgan. All right. There are a lot of issues with this case that where you sort of accept the bottom line, but the steps getting there are very complex. I'll just try to walk you through some of them. Right. It's not clear the statute was ever being enforced, and this was a total setup, this test case, right? In fact, the Connecticut legislature was trying to repeal the statute as this case was moving forward. They ultimately never had to, or I would say never did, because of the court's decision. But this is a law that was about to be repealed. It still isn't clear to me why the doctors have this right to assert a constitutional right to privacy on behalf of a married couple. It's never been clear to me why this is the case. A married couple should be the ones bringing this case, not doctors. Doctors are heavily regulated in every facet of their lives. And the notion that they have a right to prescribe a product the state's banned just has always struck me as bizarre. I'm with boredom on my tie. Thank you. Someone told me. I ate a lot of fruit, by the way. If you ever see me in person, I eat a lot of fruit. So I'm always noshing. Or say you're right. So the issue with the doctors is the right to prescribe a certain product. So all this stuff doesn't really come out in the opinion. In fact, I'm bringing it up now because it just doesn't even exist. The court sort of jumps right to the married couple rights of privacy. Now, let me just... who's next, Morgan? Jose, you here? Jose?
Yes, sir. I'm here.
Jose, could unmarried couples get contraception?
No.
Why?
I don't think so.
But wasn't the statute limited to married couples?
Yes, but unmarried couples didn't even have the right to like have children.
Oh, you're so right. That's exactly right. Tell me why. Most people miss that one. Tell me why.
I think it's just because the state or the country at the time just thought it was immoral.
Not just immoral. Was it legal for people to have sex outside of marriage?
No.
It was illegal. Yeah. Thanks, Jose. It was illegal to have sex outside of marriage, so you couldn't have unmarried couples getting birth control. I'll give you one more. The children, I think I mentioned before, the children of unmarried couples were considered, I don't like this word, but I'll say illegitimate bastards, if you will. And they were not allowed to inherit property and had other legal disabilities. So really, the only way to have kids was through marriage. That was the only way, right? So when they talk about marriage being, essential for survival, they meant to reproduce. All right, thanks, Jose. I appreciate that. So this was only about married couples, but they were really the ones who were getting contraception anyway. Okay. All right. Where am I? Okay, who's next? Okay. All right. I think Moses, you here?
Yep.
All right, Moses. So, if you can, please walk me through Justice Douglas's majority opinion. Right? What exactly is the basis for his ruling that the Connecticut law is unconstitutional?
Gosh, that's actually a pretty loaded statement.
Well, take as much as you can. Yeah. It is. I'm sorry. It's not an unfair question. But at least start us off, please.
So basically speaking, we have this right of privacy that has been implied into, or at least read into the Bill of Rights.
Okay, let me just stop you there. I think I can spend 5 minutes in just this one sentence, right? What do you mean there's a right of privacy that's been implied or read into the Bill of Rights? I think that's what you said. Implied or read into. Just share your thinking, please.
So, page 1161 of the text, I'll just use the example of one of those.
Okay.
Douglas says the First Amendment has a penumbra where privacy is protected from government intrusion.
Okay.
And so I think from the video and from science, thanks, Douglas, from science, we get this idea that during a lunar eclipse, there's a shadow, and then but there's still light that comes bouncing off the earth. And so that's the penumbra there, that light that's bouncing off the earth. And so privacy then becomes this penumbra that is present in the First Amendment.
Okay. All right. That's excellent. Okay. Very good. I'll leave you alone there. I think that's pretty solid. Okay. The core of the Douglas opinion is this concept of implied rights, and that's where that Moses used. I think it's a good word. Implied rights. Okay, so what does implied mean? I think the better way to understand implied is to figure out the opposite, which is express, right? An express right is a right that's listed in the Constitution. It's written. It's there, right? Right of freedom of speech, right? Free exercise of religion, the right to be secure from searches from the government, right? These are rights that are expressly listed. What they mean, we can argue about, but they're in there. Footnote 4 of Caroline Products in the first paragraph says if you have a right that's expressly listed, we can be confident what it means, and the courts can approach it with some form of heightened scrutiny, right? That when laws burden expressly enumerated rights, the courts review those laws with heightened scrutiny, what we now call strict scrutiny. What if a law is not expressly enumerated? Like the right of contract. Justice Douglas tells us, footnote 4 tells us, when you have a right that's not expressly written down, it's not expressly there, we give it differential scrutiny. We review such laws with rational basis review, where the government has latitude to make decisions. All right, so most medical decisions don't really affect the Bill of Rights. They don't. Prohibition on counseling for snake oil would be reviewed with a rational basis review, reviewed deferentially. But what Griswold sort of suggests is that there are some rights that are not expressly listed, but are implied from the Bill of Rights, right? The Bill of Rights suggests that these rights may receive heightened scrutiny as well. And he comes up with this cockamamie, elaborate penumbras and penumbras and emanations. I can never say it right. Emanations and penumbras, right? And you know, where the hell did he get it from? There was a law review article written in the 60s that discussed, you know, core rights and then, you know, these sorts of beams of light coming to this entire imagery. And Douglas totally botched it. Just it's awful, right? Even people who agree with, you know, abortion rights think this opinion's a joke, right? Just the actual opinion itself just is incoherent. You can agree with the outcome and admit candidly, what the hell did I just read? I feel like I just had an acid trip, right? It was the 60s. If you remember the 60s, you weren't there, as they say. But he tries to create this framework in which a right of privacy could be grounded in the Bill of Rights. Now, why? Yeah, space age. Yeah, he was high as a space station, right? But why? Erica, you here?
Yes, I'm here.
Erica, let me ask you a question, please.
Oh.
I'm sorry, you there? Okay, thank you. Erica, let me ask you a question, please. Why does Justice Douglas try so hard, so very, very hard to, you know, make this right of privacy based on the Bill of Rights? Why is he working so terribly hard to make this work?
I think so it can fit into footnote 4. He's trying to expand it.
How does this right of privacy then fit into footnote 4 under the you know, under the Douglas opinion?
How it does or how it doesn't?
In Justice Douglas's mind, how would it fit? That's the question for you.
By expanding, I think, like the Bill of Rights to include right to privacy.
So Douglas is saying if we pretend that, you know, this is implied from the Bill of Rights, we're still in footnote 4. Is that your argument?
I think so.
Now, do you find that argument persuasive, Erica?
Not really, because I mean it's not enumerated, so yeah, it's just kind of hard. It's like a puzzle piece that like doesn't fit.
Oh, good. I like that one. That's a good analogy. Okay, thanks, Erica. All right, so I think she's exactly right. There was this effort by Justice Douglas, who was a crazy dude. By the way, I'll give a little bit of... Justice Douglas was appointed to the Supreme Court when he was a very young man. He was a law professor at Yale. And he had a bad habit of having affairs with his secretary and then leaving his wife for his secretary. He did that a couple times. And he kept leaving his former secretary for his younger secretary. It happened a few times. He actually wanted to run for president, but because he was a divorcee, it was considered too scandalous. You know, a divorcee could never be president. And eventually, I think his final wife was a law student, or at least she had recently graduated law school. And it was just, he was not a family man, let's put it that way. And to read him saying how important the family is and the sanctity of the bedroom is just complete garbage. I mean, just look at how he says, like, the sanctity of the bedroom. Give me a freaking break, Douglas. You know, just the chutzpah in this guy was something else. But Justice Douglas was at least a product of the New Deal. He was a Roosevelt appointee, and he did not want to revisit West Coast Hotel. He did not want to revisit Caroline products. So he said, look, we're going to leave footnote 4 in place. We're going to leave Caroline products in place, but we're going to say there's certain rights that are part of the Bill of Rights. There's certain rights that are connected to it. There are these penumbras and these shoots of light, these emanations, other stuff, right? And that's going to be the basis for this right of privacy. And he grounds it in, make sure I get the list right. The first, the third, the fourth, the fifth, and the Ninth Amendments. And that these amendments collectively create zones of privacy. Now again, where exactly is the zone? He says the zone's in the marital bedroom. But the action the government was regulating here was not in the marital bedroom. the action the government was regulating was in a medical office. It was even a medical office. It was an office, a Planned Parenthood clinic. Right? So the zones don't even match up. Right? This was never the right case. They should have had a couple bring the suit, not the clinic itself. Okay. Now, Douglas still had to contend with the sort of allegations of Lochnerism, right? How do you reconcile this case with the presumption of liberty decisions, right? You have Lochner, you have Pierce, you have Myers, right, in Nebraska. How do you reconcile? How do you account for those other, evil decisions, right? Jeffrey here? Jeffrey?
Yeah, I'm here. Sorry, I had to unmute.
That's okay. Jeffrey, how does Justice Douglas account for these early 20th century decisions involving rights of contract and rights of teachers and rights of schools? How does he account for those cases?
Is this where he brought up the Ninth Amendment?
We're not the Ninth Amendment quite yet.
Well, I'm not really sure. I don't remember.
Well, what was Myvie, Nebraska about?
Was that was the case, right?
Good. Right, where the teacher was teaching German. And what was Pierce v. Society of Sisters about?
About the Oregon trying to pass a law that basically trying to close down private schools.
Okay, good. That's very good. All right. So let me ask you this question, Jeffrey. How does Justice Douglas account for those two decisions that were based on the Due Process Clause?
I'm sorry, I don't remember.
Okay. Kevin, you here?
Yes, good morning, Professor.
Good morning, thank you. Kevin, how does Justice Douglas account for these two decisions from the early 1920s?
Didn't he kind of try to recast them? He tried to kind of turn them more into First Amendment cases?
Yes.
Even though that's really not what the courts had originally used when they decided those cases.
That's exactly right. Thank you, Kevin. Thank you. Right, so Douglas basically pretended that Pierce and Meyer were First Amendment cases involving rights of association and rights of religious minorities and rights of free exercise of religion, right? It was not the case. Those cases were substantive due process decisions. They had to basically make it up, right? It's sort of this like, what's that word? Revisionism, right? Where you sort of rewrite history to fit your narrative. That's what the court had to do here. And he didn't even acknowledge what he was doing. You guys you see the difference. All right. Okay, so we did the penumbras, we did the 1920s cases, and that's really it, right? The opinion sort of ends abruptly, right? It's far too long, but also way too short, right? You sort of get to the end, it's like, oh, okay, that's it, right? The Connecticut law regulates the relation, the zone of privacy, therefore it's unconstitutional. It's like, oh. Is this, strict scrutiny? What is this? That doesn't, whatever, right? It was just such a, every time I teach this case, I'm like, what the hell did I just read? It's just such a strange opinion. At all these Senate confirmation hearings, they always asked, was Roe v. Wade correctly decided? And in more recent years, they start asking, was Griswold correctly decided? And, the justices won't answer that question. Like, not going to answer it. But, like, the answer is, it's incoherent, right? Just, you can agree with that contraception should be an important thing that people have, and just this decision. I don't know how to teach it. It's just such a weird thing for me. Roe's a little bit easier to teach, but this one I have no idea. All right, I'll do the concurrences in a minute. Are there questions on the Griswold majority? Questions on the Griswold majority? I welcome your insights. I honestly struggle teaching this case. I just don't know what to do with it. Okay, I got Vikesh. Macy on deck. Go ahead, Vikesh.
Hey, Professor. So I wanted to go back to something you said. You said you weren't clear why the doctors brought up this case as one of the issues. And I was wondering, what about the argument that a doctor's duty or job is to help the patient, right? To protect life, to ensure that life is, the healthiest or whatever the case may be. And then what about the fine line where the doctor goes, okay, and maybe this is an economic argument, can the parents afford having a child? How would you look at that and apply that?
Those are all good policy arguments, but what's it do with the Constitution?
I guess not as much, but so there would be policy approaches then.
Yeah, I mean, those are good arguments to make to the legislature about why the statute should be repealed. But I mean, if we're saying there's some right of privacy between the husband and the wife, wouldn't that mean that the state can't ban sodomy? I mean, in a way, Lawrence v. Texas is an easier case than Griswold. Because in Lawrence, they were actually criminalizing a sexual act, right, that was in the bedroom. Here, the thing they were regulating was not in the bedroom. They were regulating something that happened in a medical office, which is something the state routinely does. So I think what you're saying, Vikesh, is these are policy arguments that if a couple can't afford to have a kid, maybe birth control is a good option for them. That's a policy argument. But is it just doctors don't have constitutional rights to prescribe treatments, right? If the state decides to remove a license of someone, a medical license, because they were giving bad advice, you can't say, well, that's unconstitutional. I love all you, but you don't have a right to be an attorney, right? If you screw up in the state, you give bad legal advice, the state can remove your license, and you don't have a constitutional right to be an attorney. Does that help a little bit, Vikesh?
Yes, thank you.
Okay. Hey, Macy, go ahead, please.
So before you said that he went back to Pierce and Myers and argued that they were really First Amendment cases. Does that mean that we're moving back towards a substantive versus procedural due process standard in these types of cases?
Really good question. I think you have to think about what year you're looking at, right? If you're in the 1920s and 30s, you are substantive due process, right? That's how these cases we view. These are due process cases. But if you're in the 1960s, under the court's modern, but for the 1960s, these are basically viewed as First Amendment cases. And it's almost like, you rewrite old precedents sort of fit current standards. And the court does this from time to time. It's very frustrating to students, but it does happen. Does that answer your question, Macy?
Yes, it does. Thank you.
Yeah, sure. Happy to help. I mean, I do the best I can with this case. It's not an easy case to teach. I try. Lady, I think I saw your hand pop up, then it went back down.
I changed my mind. Thank you.
Okay, that's all right. All right. Any other questions on the majority in Griswold? All right. There were 3 concurrences, and to be frank, the concurrences I think are much better from a teaching perspective, right? I can explain the concurrences a lot better than I can explain the majority. The first concurrence is by Justice Arthur Goldberg. Justice Goldberg, as it went, was the Jewish justice. There was usually one at a time. You had Justice Brandeis, and then you had Justice Frankfurter, and then you had Justice Goldberg. Then you had Justice Fortas, and then they had a little bit of a break, and then I think then Justice Ginsburg eventually came to court. Right? There was always at least one Jewish justice. Well, there were 3, now there are 2, Breyer and Kagan, but we had 3 for a while. Goldberg had a very short stint on the court. He was duped by President Johnson. This is one of the biggest power plays. LBJ, President Johnson, he was a hoot, right? He wanted to put his buddy Abe Fortas in the Supreme Court. So what did he do? Johnson needed a vacancy. So Johnson went to Justice Goldberg and said, I need your help. I want to make you the ambassador to the United Nations so you can end the Vietnam War. And he persuaded him. So Justice Goldberg retired for like 3 or 4 years in the court, become the ambassador to the UN. He didn't end the war. It was a complete scam, right? He wasn't going to do anything. And that way there was a vacancy, and Johnson could put his buddy Fortas in the court. And then one more, right? A couple years later, Johnson was very, very good at making these sorts of power plays. Okay. All right. Justice Goldberg wrote his opinion about the Ninth Amendment. Now, Randy, my colleague, is one of the leaders in the world on the Ninth Amendment. It's not my area of expertise, but I can do a little bit of justice to it. The Ninth Amendment provides, and I'll read it to you, the enumeration in the Constitution of certain rights shall not be shall not be construed to deny or disparage others retained by the people. What does that mean? All right, so have you all studied in common law the concept of contracts, the expressio unius doctrine? Does that sound familiar? No, I don't know why you don't learn this. It's an important doctrine, right? Let's say I have a contract that says, an example. No animals are allowed in the house, such as dogs, cats, and, birds, right? I list dogs, cats, and birds, right? Those are all domestic animals, right? I'm saying dogs, cats, and birds are allowed in the house, but you can't have other animals. Okay? The fact that I list dogs, cats, and birds suggests I'm talking about domestic animals. Can I bring an elephant in the house? Probably not. Can I bring a lion or a tiger? Probably not, right? The fact that you list certain things usually means you're not mentioning other things, right? If you're listing certain types of animals, that means you're not allowing other things. It's a common aspect of English. If you list certain rights, the implication is you don't want other rights protected. Now, the Bill of Rights was being debated in the 1790s, and the argument was, well, if we write down these rights, people might think we don't have other rights. Right? If all we have are right to free speech and the right to bear arms, etc., those are the only rights we have. The Ninth Amendment, according to most scholars, was designed to respond to that allegation. It says, even if you enumerate, that is, you write down certain rights, there are other rights that exist. You cannot deny that other rights exist, that the people retain other rights. So at a basic level, the Ninth Amendment reflects the idea that not all rights are written down. So what's Justice Goldberg getting at? The Ninth Amendment suggests that maybe we do have this unenumerated right to privacy. Right? That maybe we have a right to privacy, we just don't know about it. Now the difficulty is this. How are we supposed to know what the unenumerated rights are? How are we supposed to know? Do we have any idea? How are we supposed to know what our rights are if they're not written down? Justice Douglas doesn't really tell us. Justice Goldberg does not tell us. How are we supposed to know? He does not tell us. Is the right of privacy protected by the Ninth Amendment? Goldberg doesn't say. Because at the time, the Ninth Amendment didn't limit the states. It limited only the federal government. So the Goldberg opinion is very thoughtful, but also only ends with an unsatisfying conclusion. We don't really know where it leads. And the court doesn't say much else about the Ninth Amendment. All right, are there any questions on the Goldberg concurrence?
I have a quick question.
Yes, go ahead.
Oh, sorry, this is Kevin.
Let's go, Kevin.
Although he doesn't explicitly say that privacy is an unenumerated right, it is a concurrence. He is saying that this law is unconstitutional and it concerns privacy. So isn't he kind of implicitly saying that privacy is an unenumerated right?
I think that's a fair question, a fair point, Gavin. I think what Goldberg was trying to do was to plant the seeds for some future opinion, that in some future case, some courts would actually rely on the Ninth Amendment to find unenumerated rights to privacy. If you notice in Roe, the district court actually cited the Ninth Amendment. So I think after the after the Goldberg opinion, judges began to look at the Ninth Amendment differently, as a different way to make up rights. Imply. Sorry, I slipped for a second. Yeah, thanks, Gavin. Any other questions on the Goldberg concurrence? I think the most influential concurrence is by Justice Harlan. Now, this name should be familiar. This is John Marshall Harlan II. He was the grandson of John Marshall Harlan I, the great dissenter from Plessy and from the civil rights cases in Lochner. And Harlan said, look, let's cut the crap, right? We have a due process clause. The word liberty's in there, right? The word liberty has meaning. We know what it is, but liberty includes this right of privacy. Let's just cut the crap. And the Harlan opinion became very influential later. Now, the difficulty with Harlan's opinion is that it's in tension with footnote 4, right? At least Douglas said we have penumbras in the Bill of Rights. And Justice Goldberg said, well, we have the Ninth Amendment, right, with Bill of Rights. But once you go to the 14th Amendment's due process clause, you are in Lochner land. Funny story. So I used to do an April Fool's joke on my blog every year, and I made them very realistic. I had these pranks. And then one year in 2010 or so, I made a joke post that I was making a constitutional theme park called Constitution Land, with all these these rides and themes and areas based on various Supreme Court cases. Lochner's Bakery for concessions. I had all these very funny jokes. I actually got a cease and desist letter from some guy who had, I don't know, it's even possible, who had created a trademark for Constitution. I'm sorry, a copyright for Constitution Land, and he had a reserved right to make a constitutional theme park. It wasn't real, but he actually had filed the paperwork, and his lawyer sent me a demand letter demanding they cease and desist creating a constitutional theme park. And like I was just like, oh my God, lawyers are so stupid, right? And then I remember writing back to him. I said, this was published on April 1st. This is an April Fool's joke. I have no interest in doing this. Thank you. I never heard back from him. He actually retained a lawyer to send me a demand letter. He must have been so embarrassed. I think I actually had Lochner land or something in the theme park. But anyway, the difficulty with the Harlan opinion is it's inconsistent with footnote 4. He doesn't really square that circle, but he's sort of saying, let's just focus on the due process clause. Oh, that's it. Yeah, you found it, Colin. Constitution Land. I haven't looked at this website in there it is, 2009, right? The virtual amusement park, people love the Constitution. Oh my God. I can't believe this website still exists. I haven't thought about this in years. Oh, this guy, he was somewhere in upstate New York. I can't remember his name. It's not very important. Anyway, I think he has problems with Walt Disney's logo also at the Disneyland. Oh, look, he has 5 flags instead of 6 flags. All right, so he has 5 flags over Constitution Land. Anyway, that's a Harlan one. Justice White had a different concurrence. He basically said, yeah, this law is, violation of due process. All right. We have 2 dissents, Justice Black and Justice Stewart. Justice Black says, oh, Lochner, right? You forget West Coast Hotel, and now you return to the dangerous and discredited Lochner case. It's funny, during the arguments, he didn't even know what Lochner was about. He forgot it. He thought it was about, there was another case that involved regulation of the weighing of bread, that bread had to weigh a certain amount. And it was very hard for small bakers to make bread this exact amount. You have to use special tools to do it. But he says it's all about Lochner. And you're going to see how often Lochner comes into play in dissents. Lochner cited in the Griswold dissent. Lochner cited in the Roe dissent. Lochner cited in the Casey dissent, Planned Parenthood versus Casey. Lochner cited in the Obergefell dissent in gay marriage. It's like this case does not die. It just keeps coming back in every freaking case. It's amazing. Just Lochner everywhere. This poor baker from upstate New York, his case is just perpetually in the U.S. reports. Just perpetually. All right. And then you have Justice Stewart, who very famously said this was an uncommonly silly law, which I think how most people probably view this statute. But there's nothing unconstitutional about it. All right. Questions on Griswold? Questions on Griswold? No? Okay. All right, let's move on to Roe then. Our last, or I guess our second and last case today. The story of Roe, is complicated because of the actual person, Jane Roe herself. Did anyone see the documentary on Norma McCorvey? It was on FX. It came out a few months ago. I haven't had a chance to see it yet. Did anyone watch it? So Jane Roe, her real name was Norma McCorvey. She was a woman who lived in Texas. She actually she died in the last year. She lived somewhere in Houston. I think it was maybe Sugar Land, but she lived somewhere in the Houston area. But she had a very tragic life. It was sad in many ways. Oh, I'm sorry, James. Thank you. She was in Katy. She had a child, and she gave up for adoption. Then she had another child and gave up for adoption. She became pregnant a third time, and she wanted to obtain an abortion. At the time in Texas, an abortion was only obtained if it was needed to save the mother's life. She did not have this situation. It was a normal pregnancy. She was informed, I think incorrectly, that if she was raped, she'd be able to obtain an abortion. So she told people that she was raped. It turned out it wasn't true. That still didn't let her get one. Then she started looking around for illegal abortions. And she came across these two lawyers for the abortion rights groups. And McCorvey just wanted an abortion. She didn't want to have the child. But the lawyers sort of, how do I put this, pressured her. Because they needed a plaintiff, right? They didn't want to litigate like Griswold, where you had abortion doctors, because that was unclear. They wanted actual women who were pregnant, who wanted to obtain an abortion but could not get one. And they were able to get Norma McCorvey to sign up to the case under a pseudonym, a fake name, and they just picked Jane Roe. Instead of John Doe, Jane Roe, they just modified it. There was another case from Georgia that involved a doe. So this was Roe and you had doe. Okay. Norma didn't really do anything in the case. She just put in the affidavit, but she had to actually carry the child to term. And eventually the child was given for adoption. Lainey asked, does anyone know if the kids know about their biological mother? I have no idea. I don't know in Texas what the laws are governing privacy of the biological parents. I don't know the answer. I'm sure that was going to be a hard conversation, that your mother was Norma McCorvey. That'd be a hard one. Fast forward after the case, just a thumbnail on McCorvey, she became this sort of like mini celebrity in the abortion rights communities, and she was not treated very well. I mean, she was basically just a face that they needed someone to market and fundraise off of. They didn't really care about what she said. Later in time, McCorvey had, how to describe it, she changed positions, at least publicly. McCorvey was probably a lesbian. She was never totally out about it, but she lived with another woman for many years and they had a relationship. But then in the 80s, she started becoming a little bit more religious. Again, it depends. At different times, she said different things, but she became more religious. And she broke up with her partner of many years. And then she eventually said she was born again and became a Christian and became a staunch pro-life advocate. And she spoke out against Roe v. Wade, and she regretted she was part of it and said it should have never happened. But as things go, she was treated very poorly by the pro-life community, and she was, treated very poorly by them and just used as a placeholder. And she would have to go speak places. Now, I'm hedging a little bit because Norma gave this documentary interview in her last years of life, where she now claims that she was never actually religious and that she was using the churches for money. And that she was doing this entire thing just for thank you so much for that. She was basically paid to speak out against abortion. And she actually did it for the money, and she didn't really care. And that, in fact, she remained to her dying days in favor of the right to abortion. So I honestly don't know what to make of her. And because she said so many different things over her lifetime, I have no idea. It's this sort of this puzzle of a person behind this hugely significant case. So I have no idea. While she was still alive in Texas, I thought about trying to reach out to her. I was like, "Now leave this woman alone. She's had enough, heartache and enough stuff in her life. I didn't want to mess with it." But none of that really matters, right? She's called Jane Roe, and that's it. And there's no. Right, the case is about her, but not really. The case is not really about her at all. Okay? All right, so any questions? I just give that a little thumbnail just because you don't usually think about there are people behind these cases, and it's very hard. It's very, very tough. I mean, to be a litigant in a constitutional case, the amount of pressure you have. She was just a woman. She didn't. This is not what she signed up for. She didn't know what she was getting herself into. Yeah, Moses. There was a documentary on FX, the channel FX. It came out the last 6 months. I had not had a chance to watch it yet, but I think James put a quote from there. All right, so let's walk through the opinion of the Roe decision. Justice Blackmun, again, no relation, wrote the majority opinion in Roe. And the opinion itself doesn't make exactly clear which provision of the Constitution they're relying on. It's generally viewed as based on the 14th Amendment's Due Process Clause. But Justice Blackmun is not committed to that answer. He basically says, well, maybe it's the Due Process Clause, maybe it's the 9th Amendment, we don't really know. But what we do know is the court puts together this sort of framework to assess abortion laws. For whatever reason in law, it's always 3, right? You have Justice Jackson's 3 zones, you have strict, intermediate, rational basis scrutiny, right? I don't know why. Lawyers like 3s, and just this happens to be another 3, right? Just happens to be, actually, naturally, biologically, they're 3. But for whatever reason, lawyers always have things in 3s. I can't explain to you why. And the court divides the pregnancy up into 3 tiers. No, not 3 tiers. 3 trimesters, which is, pregnancy is roughly 9 months, usually. And what the court suggests is that you have these competing interests, right? You have the woman who has an interest in terminating the pregnancy. You have the state that has an interest in protecting the mother's health. And then you have the state also has an interest in protecting the life of the fetus. And the court comes up with this sort of like a spectrum, a continuum, that as the fetus grows and develops, the interest changes. So earlier in the pregnancy, the woman has a stronger interest in terminating the pregnancy. But later in the pregnancy, the woman's interest diminishes. You notice I keep saying woman rather than mother, and I'll just mention this. Maybe a year ago, there was a spat at the Supreme Court where there was an abortion case. The facts are not very important, but Justice Thomas used the phrase mother, the health of the mother, right? And you'll see this in all the cases, health of the mother's health, right? And then Justice Ginsburg replies like, a pregnant woman is not a mother, especially a pregnant woman trying to seek an abortion is not a mother. And I hadn't quite considered that before. And then I got this very lovely email from another professor saying that I screwed up at the word mother inside the book. And, after back, I was like, okay, so fine. I'll change it to woman in general, because I think it's probably more accurate. Although the cases all say mother. If you just read it, they say the mother's health. So you'll see it both ways. That's why I'm sort of, I'm correcting myself. I try as best I can to use the right terminology. In other words, I don't want the message to be diluted because I'm using words that people that aren't technically accurate. I'd rather use accurate words than just arguing the substance rather than, anyway, so that's why I keep correcting myself. All right. But I apologize if I slip because my brain doesn't always work as quickly as it should. All right. So you have this interest in the health of the woman, right? And the interest in health increases as the pregnancy goes along, right? Why? Because the risks from pregnancy increase as you go further along. There are additional risks of complication, different things can happen, and the state has a greater interest in protecting the woman's health as you go farther along. Okay? And then you have this interest in fetal life, which is the one that the court seems to struggle with the most. The court seems to say that, in the 9th month, when you have a baby that's full term and the baby can survive on its own outside the womb, at that point, the state has an interest in protecting the fetus. They don't have to. There are some states in the union that permit 9th month abortions. They exist. New Mexico is one of them. Till the day before. They're rare. It doesn't happen often, but they do happen. But the state can choose to prohibit abortion when the child is basically full term. But earlier in the pregnancy, the state's interest in fetal life isn't quite as significant. Now, where's the dividing line, right? The court seems to suggest that the way to divide these various interests is based on a common feature of pregnancy, which is the trimesters. If any of you either have had kids yourselves or you've had family members who have kids, doctors speak a lot about trimesters, right? I just went through this. I just had 2 kids in the last 2 years or so, right? At each trimester, different things happen. There's different development. There's different types of medical exams you need. There's different kinds of tests you have to take. Right? This is like a natural thing that doctors use, these 3 trimesters. It's there. And the court adopts these 3 trimesters as part of its constitutional analysis. Right? And explains that at each stage, there are different powers of the state. So, for example, in the first trimester, that's the first 3 months of the pregnancy, the state has very little power. What can the state do? Not much. The state can regulate the doctors and the facilities that provide abortions, but this is just the general regulation of facilities, right? They can't prohibit or even restrict abortions to protect fetal life. At this point, the doctor and the patient have a decision. Now, I think earlier, it was Vikesh or someone asked me about, shouldn't there be some sort of constitutional right between the doctor and the patient? And I said, where the hell does that come from? That seems like a policy argument. Well, here it is. I think that's what Vikesh was getting at. I think he was probably hinting at this. But the court just says this. Doesn't really find any basis in law. It just sort of says it. The second, and I apologize, I'm lecturing because I'm short on time. I do want to finish this today because we'll give a lot more to class for Monday. But the second trimester, there are further developments, right, between 3 and 6 months. Now the state can enact regulations to promote the what they call maternal health, or I guess you say the woman's health now. Right? What would that actually mean? For example, if you're performing an abortion, you have to have certain licensing, right? You have to have certain types of anesthesia available. You have to have certain types of cleanliness. You need to have facilities of a certain standard. There are certain things you could do to make the procedure safer for the mother, for the woman. Okay? It's hard. It's hard to say mother. I keep slipping. I'm trying my hardest, but it's hard. Especially when the case says mother. Okay? Now, the third semester, the third trimester, no, not third semester, the third trimester, I guess you're in your third semester of law school. The third trimester gives a state the most latitude, where they now have an interest in protecting fetal life. In theory, at least, the state can regulate or even ban abortions during this period. Although, to be frank, they can't actually ban it. There's exceptions for the health of the woman, and health is construed very, very broadly to include mental health. And I'll be frank, it's even in the final stage, it's often possible to obtain it, even if it's otherwise banned. Not always, but it's possible. There are lots of health conditions that happen if a woman gives birth in the 9th month. There's preeclampsia, there's high blood pressure. There's lots of things that could happen. Justice Blackmun says that these decisions, these 3 trimesters, allow the government to put increasing restrictions on abortion as the term progresses, but those interests must be tailored to the recognized state interests. So not all restrictions are permissible. The court doesn't use the phrase, oh no, my notes getting unstable. Uh-oh, it's going to cut out. The court does not use the phrase strict scrutiny. The court does not use the phrase fundamental right. But I think the analysis in Roe is best viewed as strict scrutiny. And I think the analysis in Roe is best viewed as saying this right to privacy, this right to abortion is a fundamental right. They don't say that outright, but that's why I think it's the best way to understand the opinion. Right? So in other words, under Roe, we have this fundamental right, and we use strict scrutiny to review abortion laws. Basically, before the 3rd trimester, it's impossible to ban abortions. And the state's interest in protecting the fetus only kicks in month 6. All right, everyone get that, right? That's the lay of the land for Roe. It will be modified later. We'll do Casey in class on Monday. But at least for Roe, we have a fundamental right with strict scrutiny. And the state's interest to protect fetal life only kicks in the 6th month. And the interest protecting the woman's health kicks in the 3rd month. Yes, Macy, go ahead.
People always talk about challenging Roe. What would be the basis for that challenge? Like, what in this case is questionable that would be challengeable? If you have time to answer that.
Sure. Where do I start? Well, I'll ask you, Macy. What is the constitutional basis of Roe?
The right to privacy.
And where does that right come from?
Griswold.
And where does Griswold's right come from?
They kind of make it up.
Okay.
Ninth Amendment, Bill of Rights.
Penumbras. Yeah, that's your answer, right? It's a made-up right. The court just made it up. Right, and it's not just... This is why whenever they ask about Roe, they should ask about Griswold as a follow-up, right? Roe, I think, follows mostly from Griswold, right? It's not perfectly, but I think it follows. But I think the argument is Penumbras is, it's made up. It's not real. We'll talk about overruling Roe in the next case, and we'll spend a lot of time on it, but that's the short answer. But it's amazing, 50 years later, people are still talking about this decision. It's still a live issue. When Roe was decided in 73, I know you won't believe this, but abortion wasn't controversial. In fact, most religious groups actually, except for the Catholic Church, favored at least some rights of abortions, right? But Roe created a backlash among conservatives that basically galvanized. They rallied around Roe, saying we need to get rid of this case, and that was it was in some views a mistake. Justice Ginsburg actually criticized Roe, saying they went too far. They shouldn't have made this national right to abortion basically at any point after before the third trimester. This was a mistake. The court was sort of moderated in Casey in 1991. But Roe would be the law of the land for some time, for 20 years. Okay. Questions on the Roe majority? Oh, Raymond, I am not getting into church teaching. That's beyond my pay grade. Questions on the Roe majority? None? Nothing? I don't believe you. You're burned out, Tax? Oh, God. Oh, man.
Professor, this is Moses. I do have a question.
Okay, go for it, Moses. Thank you.
I think I read it somewhere. But we just finished talking about we've just talked about sex, gender, and we just talked about the means ends fit analysis for that, and we said substantially related. But I don't see that here, even though we got this substantially related stuff around the same time. So why can't the court ground it in
a strict scrutiny analysis, you're saying?
Yes. Or no, the intermediate analysis, I guess.
Well, let's just be careful, Moses, right? The sex don't giggle. The sex cases we studied. By the way, I'll come to your question. Justice Ginsburg made a big point of always saying gender instead of sex, right? And why? Because people giggle when they hear the word sex, and she'd always say gender instead of sex. But now, thank you, Justice Gorsuch, it's only sex because sex gets you to sexual orientation. So we're all just flipped, right? But I want to come back to your question, Moses, right? Craig v. Boren and Frontier were cases about the Equal Protection Clause, right? Those are classifications based on sex under the Equal Protection Clause. Here we're not dealing with sex-based classifications. We're dealing with the Due Process Clause and fundamental rights. But we still have the term strict scrutiny. So I think the majority is basically using strict scrutiny. They just don't say it. Now, let me throw one more at you. Justice Ginsburg always rejected the substantive due process argument. She said this is nonsense. Here's how Ginsburg described it. She said, every abortion law focuses entirely on women because only women can give birth. Therefore, it's sex discrimination. People like that argument. I don't know. It never got anywhere with the courts, but that was Ginsburg's preferred position. She said, look, this is like Frontiero and Craig, right? This is all restrictions on women because only women can give birth. That was the RBG argument. Does that... Moses, does that clear you up a little bit?
That gets it there.
Okay, good. All right.
Thanks.
And we're not talking about normal standard review. That too soon. All right. Any other questions on the majority in Roe? I do want to get to the dissents, at least briefly. The vote in Roe was 7-2. It wasn't close. Do you think it's 5-4? This was 7-2. In fact, most of the judges, the majority, were Republican appointees. What I'm trying to get at is abortion was not the sort of right-left issue it is today. It became that later. By the 90s, without question, it became right-left. But in the 70s, it wasn't. Indeed, Justice Blackmun was a Republican appointee. Yes, Aaron, go ahead.
Oh, I just had a quick question. I remember when the first day you were talking about all the tiers of scrutiny, and number 2 was the undue burden standard. Is that what this is? Or
not yet. We'll get to that on Monday. Okay. Roe reviews the abortion laws with what's basically strict scrutiny. On Monday, we get a new abortion test called the undue burden test. So from 1973 to 1991, they used basically a strict scrutiny test. But from 1991 till Justice Barrett's confirmation, they used the undue burden test. Oh, sorry, that was too soon. But at least for the present moment, for your exam at least, undue burden is the correct standard. All right. Let me do the dissents quickly. If you need to go in a minute, that's fine. Oh my God, I did 0 poll questions today. I'm awful. I'm sorry. I apologize. The 2 dissenters were Justice Rehnquist and Justice White. Justice Rehnquist was a Nixon appointee, and Justice White was a Kennedy appointee. Justice White was very livid. He was a liberal Democrat, but he was very much opposed to the abortion cases till the very end of his term. And he explained this was a raw exercise of power, or an exercise of raw judicial power. And the court, maybe its authority, but they should not be doing this. Justice Rehnquist dissented. He said, this is Lochner. You know, you're citing Holmes, but you're really engaging in the Peckham majority. And he's right. For all the hatred of Lochner, this is Lochner times a million, right? Lochner upheld most of the health and safety laws in New York. Yeah, I was thinking more. I was thinking the Brady Bunch reference, Lainey, but I don't know if anyone would get that reference. A little bit too dating myself. Russia, COVID, Marsha, that sort of thing. But the majority in Roe is Lochnerism. You can draw a distinction, say, well, this is about personal rights and privacy rights, but that's a made-up distinction. That was not actually present. And the court doesn't really acknowledge this. All right. That's what I want to talk about today. What you need to know between class today and class on Mondays has proved to be very controversial. That almost immediately after Roe, a movement formed to overrule the case. And almost immediately after Roe, people were marching in Washington to protest the case. And the Republican Party latched onto this very effectively and said we need to appoint conservative judges who would be willing to overrule Roe. They tried for almost 40 years. They didn't get there. Maybe they're there now. We'll see. All right. I'll start the minute poll. And I'll be back in office hours in about 20 minutes, 12:30. Thank you, everyone. I'll see you all on Monday.